Historic day. It's the first time the High Court has considered any presidential candidate's eligibility under the 14th Amendment. Now, central to this case is Section 3 of the 14th Amendment, which bars any officer of the United States who swore an oath to the Constitution from office if they engaged in insurrection. You may remember in December, Colorado State Supreme Court barred Trump from the state's ballot after finding the former president did engage in insurrection for his role in the deadly January 6, 2021 Capitol riots.
We have live team coverage breaking down today's arguments. Denver 7 reporter and attorney Jessica Crawford has some legal analysis on the claims made by lawyers representing both Colorado voters and the former president.
But first, let's begin with our Brandon Richard. Brandon, tensions are high here as this case is expected to have profound implications for this year's election.
Yeah, that's right. And you know, the justices seem very skeptical of Colorado removing former President Trump from the ballot. Even one of the liberal justices, appointed by President Obama, wondered why Colorado believed it should even have this type of authority.
The question the U.S. Supreme Court must decide: did the Colorado Supreme Court get it wrong when it disqualified former President Donald Trump from the state's primary presidential ballot? Trump's attorney, Jonathan Mitchell, says there's no doubt it did.
The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons.
In its ruling in December, Colorado Supreme Court determined Trump engaged in insurrection on January 6th and is no longer qualified to become president again under Section 3 of the 14th Amendment. That amendment says no officer of the United States shall hold any office who engaged in insurrection. Mitchell argues Trump did not engage in insurrection and says as president, he was not considered an officer of the United States.
Officer of the United States refers only to appointed officials, and it does not encompass elected individuals such as the president or members of Congress.
He says even if Trump did engage in insurrection, a state cannot exclude any candidate for federal office.
And any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office.
When it was time to question the other side, the justices seemed very skeptical about Colorado's position. Justice Elena Kagan asking why a single state should have the power to decide who gets to be president.
If you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation.
Despite that line of questioning, Colorado's Secretary of State remaining optimistic.
It's uncertain whether the questions the justices are asking indicate where they'll end up going in their decision. So I would caution folks to getting too far out in front.
Now, Colorado's primary is March the 5th. The Secretary of State says ballots for military and overseas voters, well, those were sent out last week. Ballots for most other voters, those will go out next week. So she is hoping that the court will make its decision before then, perhaps in the next week.
Not a whole lot of time there. Brandon Richard reporting tonight. Thank you. Now let's go ahead and bring in Jessica Crawford. The U.S. Supreme Court hasn't had such a blockbuster election-related case since Bush versus Gore in 2000.
Now, Jessica, justices didn't focus as much on Trump's January 6th actions as much as the meaning behind this insurrectionist clause in the Constitution itself.
Yeah, and they took a look back at the history, too. So conservative and liberal justices both questioned whether the insurrectionist ban was intended to apply to former presidents. There were also questions about whether the ban could be enforced without Congress enacting a law about that first. Justice Ketanji Brown Jackson noting that the insurrection clause did not include the word president. She also noted that it specifically listed other officials who would be covered, for example, members of Congress. And that is one of Trump's main arguments. The court also focused on the origins of the insurrection clause. It was drafted as a means to block former Confederate officers who were elected to office after the Civil War. Chief Justice John Roberts telling the attorney for Colorado's voters that his arguments are, quote, at war with the history of the 14th Amendment.
I mean, the whole point of the 14th Amendment was to restrict state power, right? Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states to enforce, implicitly authorized, to enforce the presidential election process. That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
And many legal experts at this point expecting the court to lean in Trump's favor based off of the questions that the justices were asking today.
Including potentially how they were asking, who they were cutting off, the tone that was also going on during that hearing. Now, Jessica, during these arguments, the Chief Justice, once again, John Roberts, he also questioned whether this could lead to other states kicking other candidates off of their ballot.
Yeah, and so this is the slippery slope theory that justices often have to grapple with, regardless of what decision that they're making, because they understand that they're not just making a decision for this moment, but that this decision will continue to impact other elections. Chief Justice John Roberts suggesting that other states may try to use this same clause to get rid of candidates that they just don't like.
If Colorado's position is upheld, surely there will be disqualification proceedings on the other side, and some of those will succeed. I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
And Colorado Republicans did ask for the justices to make their big decision before Super Tuesday, but really echoing what Brandon had to say earlier, very likely we could get this decision just within the next few days here.
Because Super Tuesday, that big primary, less than a month away.
Absolutely.
Attorney Jessica Crawford, thank you so much.
Thank you.